Good afternoon, ladies and gentlemen, and welcome to this week's Vincent's webinar presentation, brought to you by our Insolvency division and covering the aspect of Safe Harbour and the new legislation introduced as part of the insolvency law reforms of 2017. I'll just give us a couple of minutes to allow other people to log on. And we'll try and get the presentation commenced in the next minute or so. So, as discussed, my name's Damien Davis. I am a Senior Manager in the Vincent's Insolvency and Reconstruction department. I've had experience both here in Australia and overseas in the United States, the UK and the Middle East. I specialise in receiverships, personal bankruptcies, liquidations, administrations, and Part 10 arrangements. I'm originally from Sydney and have moved up here probably about 3 or 4 years ago to join Vincent's in their insolvency department. So today we'll be having a look at the Safe Harbour regime, which was introduced in September of 2017. In particular, we'll go through what is the Safe Harbour provisions, what are the limitations upon directors who seek to claim Safe Harbour, what are the practical implications on not only us as insolvency administrators, but you, where your clients may seek to talk to you about the Safe Harbour regime. And then if there are any questions, we'll look at those. If any party has any questions, feel free, please, to enter those into chat, and I'll monitor those on an ongoing basis and hopefully answer those as the presentation goes along. So, the Safe Harbour regime, or the changes, were introduced by the Treasury Law Amendment 2017 Enterprise Incentives Bill 2017, which was introduced in March, underwent a number of changes and was finally passed on the 11th of September 2017. This bill also introduced the changes to the ipso facto laws and was slightly different from the Law Reform Act, which was passed again a little bit earlier, but obviously a year earlier, and was introduced through March and September of 2017. So the Safe Harbour regimes were not necessarily included as part of the first wave of insolvency law reform that was introduced during the course of 2017. It was a matter that was open for some discussion, and again brought in about by subsequent legislation that not being passed until September of 2017, where it was given royal assent and became effective from 1 September of 2017, so it was slightly backdated. The effect of the legislation was to make changes to the existing Corporations Act, in particular the insolvent trading provisions enclosed in Section 588G of the Act. And as we'll go through, I'll explain to you what those actual changes actually were. So, formally underneath the insolvent trading provisions of the Corporations Act, a director would be held personally liable pursuant to Section 588G2, where they were a director of a company at a time when that company incurred a debt. The company was determined to be insolvent at the time that the debt was incurred, or became insolvent as a result of incurring that debt, and there were reasonable grounds on the director's perspective for suspecting that the company was insolvent or would become insolvent. In those particular sets of circumstances, a insolvency administrator would be able to take action against the director, holding them potentially personally liable for debts that were incurred at that time and at subsequent periods leading up to a liquidation of a company. The Safe Harbour regime has sought to modify this particular section of the Act, it hasn't provided a defence, but it's provided what can be described as a carve-out provision within the insolvent trading claim, which provides a degree of protection for directors who take steps to deal with their company during the period of time that they believe or should have reasonable grounds to suspect that their company is insolvent. So what it actually has done is that it's inserted the new section of Section 588GA into the Corporations Act, which basically says that the insolvent trading liability provisions will not apply to a director in respect of a debt if, at a particular time after the person suspects, that is the director, suspects the company may become or be insolvent, the director starts to develop one or more courses of action that are reasonably likely to lead to a better outcome for the company, and the debt is incurred directly or indirectly in connection with such a course of action. So, what does that mean? Well, essentially, it relies upon a director taking steps to achieve an outcome as defined by Section 588GA7, an outcome that is better for the company than the immediate appointment of an administrator or a liquidator of the company. So, what is an action that is reasonably likely to secure such a better outcome? Well, the Act provides under Section 588GA2 a number of factors that may be determined or may be reviewed to decide whether the director has taken steps which are reasonably likely to provide a better outcome to the company. And that is that in making those steps, the director is fully aware of the company's financial position, that the director has taken steps to ensure that there is no misconduct by either officers or employees of the company during that period of time. Such misconduct would be incurring debts unreasonably, whether they have taken steps to ensure that the company keeps appropriate financial records, whether they have sought the advice of an appropriately qualified and informed identity, or whether the person has developed a plan for a restructure which is designed to improve the company's financial position. So essentially what happens is that under the new legislation, Section 588, the insolvent trading provisions, have been slightly modified to allow for a period of time where a director comes along and says, okay, my company is insolvent or likely to become insolvent. Am I going to take steps that are available to improve the position of the company and the company solely to undertake a better set of circumstances? And that may involve going out and seeking additional funding. It may involve a partial sale of the business. It may involve a restructuring of the business's operations. It may involve any number of different things. During that period of time where the company incurs debts that are associated with those steps, and should those steps obviously then lead into a position where the company is eventually liquidated, the director will be immune from prosecution or have a carve-out in respect of their prosecution for an insolvent trading claim brought by a liquidator. That is, if there are any debts left as a result of that during that period of time, the director will be able to say, well, I'm claiming the safe harbour, and accordingly there is effectively an ability where the liquidator is unable to claim those debts as part of any insolvent trading claim. There are some caveats in respect of that, obviously. If it becomes reasonably obvious or reasonably apparent that the company is not viable, the director must make adjustments to their course of action. So essentially, if a director decides on a course of action designed to restructure a business and it turns out that that course of action isn't correct, they're fully entitled to go about looking at alternative sources of action and having an alternate method of restructuring. But once they've determined that those courses that they've selected are not viable, then they need to, or it will not lead to a better outcome, they need to look to engage in voluntary administration or have the company wound up by liquidation. The Safe Harbour provisions will be independently reviewed by the government. It hasn't yet been determined exactly what that independent review will look like, but this review will occur within the next 2 years, within 2 years of operation. There were a number of concerns raised by industry groups associated with the Safe Harbour provisions, and we'll go through what some of those concerns were. But there was some general feeling that the legislation as it's currently drafted is perhaps a little bit too broad. Then again, there are also counter opinions to say that the legislation as drafted didn't go far enough to protect directors who were taking reasonable steps to attempt to either revive or resuscitate their companies in circumstances where they feared that insolvency was a potential outcome. So a director who's claiming the Safe Harbour provisions will need to provide evidence to a liquidator that they were taking reasonable steps and that those steps were reasonably likely to provide a better outcome for the company. It's suggested in the explanatory memorandum and in various notes provided by professional bodies that this burden, evidential burden, is actually going to be a fairly minor one to achieve. Generally to show that they have potentially contacted an outside advisor, or they have made inquiries about obtaining alternative finance, that they have taken steps to try to sell part or all of the company's business or assets. So it's a relatively low barrier in which to meet, but they are at the first instance required to prove that they've made those steps. Once they have established that that is the case, it's then up to the liquidator, who then has the burden to be able to show that the steps that were taken by the director and have been identified by the director were not reasonable steps, such that they could reasonably establish a better outcome for the company. If a liquidator is unable to do that or unable to show that the steps were completely unreasonable, then the Safe Harbour provisions will apply. So as you can see from this particular set of circumstances, it's not the establishment of a new insolvency regime by any stretch of the imagination. It really has little impact upon creditors per se. It is effectively a carve-out provision for a director that exists in hindsight. So it won't be applicable until after a liquidator is appointed to or an administrator is appointed to the company, and it effectively exists to limit the liability that directors might face in the event of insolvent trading. And essentially it relies upon the existence of insolvent trading in which to kick in. There's no provisions within it to force directors or force creditors rather to cease enforcement proceedings. There's no provisions within it to require the company or directors to correspond with creditors and advise them that they are seeking Safe Harbour protection. There's no formal arrangement effectively around what a Safe Harbour protection may involve. It could involve any range of activities undertaken by a director the provisions themselves don't require that the director establish that they were trying to get a better outcome for creditors, even in the circumstances. The provisions as they currently stand and are currently written merely require that the company itself, that steps were taken by the director to improve the position of the company itself. And that may involve, as I've said, the sale of certain assets, sale of business, seeking additional funding, any one of those sorts of arrangements, provision of additional securities over the company. There can be any number of different arrangements that are available. There are some limitations on directors in relation to their ability to seek protection or seek the safe harbour provisions once a company has gone into liquidation and the liquidator rather, has come and sought a recovery underneath the insolvent trading provisions. The first of which is that the director or directors will be unable to apply or seek to apply the safe harbour provisions in the event that they do not meet the employee entitlements of the company on an ongoing basis, including superannuation contributions. Now, there was some question when this legislation was originally introduced in March of 2017, which sort of said, well, what does that actually mean? Does that mean that the company needs to put aside enough money to cover their employee entitlements? And there was a bit of development in respect of how the legislation was drafted to determine what the actual implications, the practical implications of this particular section are. But essentially, what it's come down to is that where entitlements accrue in the ordinary course of business, the company must ensure that they are discharged. That just means that effectively the employee's wages are paid, that the superannuation contributions are made in accordance with the appropriate timelines, usually obviously on a quarterly basis at a minimum, and that will pretty much be the limitation of it. If the restructuring arrangement involves the dismissal of certain workers, then the company would also be obliged to ensure that any annual leave or other entitlements, long service leave, redundancy entitlements, were all met and paid as and when they fall due as part of those arrangements. In circumstances where the company is unable to protect its employees and unable to protect its entitlements, the safe harbour provisions will not be available to directors. The next restriction on directors and their application for safe harbour is that the directors must ensure that the company complies with its reporting requirements as it would if the company were solvent. In general, this effectively relates to the lodgement of outstanding tax lodgements, BASs, fringe benefits tax provisions, income tax as and when it becomes due, company tax returns, etc. Those particular provisions need to be met in the ordinary course. It's a little bit open, although it's generally accepted that it does mean that all outstanding lodgements need to be brought up to date, and that ongoing lodgements need to be made in accordance with the provisions of the Act. There is some wording within the legislation that calls for substantial compliance, particularly in the explanatory memorandum associated with the legislation. It calls for substantial compliance rather than full compliance, but there is a bit of a question as to exactly what the difference between these two matters would be. There certainly is within the explanatory memorandum no real establishment of, you're allowed to miss one or two lodgements in order still to comply with the substantial compliance benchmark. is a position that seems to indicate that there will be little sympathy provided to directors where they are missing particularly BAS payments or BAS lodgements and company tax return lodgements. Again, to a certain degree, this provides an establishment of a director understanding the financial circumstances of their company and also understanding their outstanding lodgements and their outstanding debt to the tax office, being obviously one of the major creditors and one of the most likely creditors in respect of any particular winding up. It does fall back within the compliance, as we saw previously, that a director and the advisors associated with the turnaround arrangements would be fully aware of the company's financial disclosure and financial position as part of this entire process and wouldn't be in a position to get away from it. Now, one thing that needs to be noted is that as part of lodgement of the company's taxation obligations, there is not an extension of that to payment of the company's tax debts as and when they are required as part of those lodgements. So if you do have, say, a BAS lodgement during this period of time that you wish to claim Safe Harbour and you're unable to pay it as a result of the restructuring, or but your belief is that once the restructuring is complete, you will be in a position to pay it. So long as you've ensured that that BAS documentation is lodged, the payment of the associated debt is not necessarily a requirement. Similarly, it's not a requirement to bring your outstanding tax position or your outstanding pre Safe Harbour revision tax debt up to date prior to seeking to claim the Safe Harbour provisions. So that is at least some degree of relief for directors in terms of making these sorts of claims. The Safe Harbour rule will not cover all debts, and in particular, it will only cover debts that are connected with the course of action that the director is undertaking in order to restructure the business and provide a better outcome for the company. And it will relate only to the period of time from when the director makes the decision to undertake the course of action, and will end effectively either when it's no longer likely to obtain a better outcome, or there's an unlikelihood that the course of action will be successful. So if there's a period of time in which a director starts to take this action and then, say, 2 or 3 months down the line, makes the determination that the business can't be either refinanced or sold, and then continues to trade again on for another 2 or 3 months, it's possible that the liquidator will be able to deny the Safe Harbour claim for the second period where the business continued to trade while the director was aware that the business couldn't be sold or refinanced. The process will be, or the Safe Harbour period will cease on the appointment of external administrator to the company. Specifically, that would be the appointment of either an administrator or a liquidator. The new legislation has effectively carved out the appointment of a receiver as being something which terminates the Safe Harbour regime. So even if a receiver were appointed, the director would be able to still claim Safe Harbour during that period of time while it was trying to perhaps refinance the business, seek alternative funding arrangements. In circumstances where the company incurs a debt and the director does not have reasonable grounds to suspect that they will be able to repay that debt during the Safe Harbour regime, those debts will also be excluded from the protection afforded by Safe Harbour in respect of any insolvent trading claims subsequently brought against the director. So the director has to have a reasonable, again, a reasonable idea that they're, or a reasonable belief rather, that their suggested courses of action to restructure or refinance the business has a prospect of success and a prospect of achieving a better circumstance than the immediate liquidation of the company. The next, or the last rather, limitation on Safe Harbour is that the director will be unable to rely upon the claim of Safe Harbour in the event that they do not provide all books and records associated with the process and associated with the company to the liquidator. So effectively there's a provision to say, if you rely upon books and records that you haven't provided to the liquidator once a demand is made of you to prove that you were taking those steps, the reasonable steps, then the Safe Harbour provisions will not apply. So if a liquidator can't assess themselves the validity of what it is that you've done or the history of what it is that you've done, then you yourself as a director do not have the ability to claim the Safe Harbour provisions contained within the Act. So again, very important from a director's perspective that if the company does eventually end into liquidation, that they provide all the books and records associated with the process to the liquidator, and certainly from an external advisor's perspective, copious notes associated with the decisions that were made during that period would be, and from a director's perspective as well, copious notes associated with decisions that were made and processes that were undertaken would be of great assistance in terms of a director being able to successfully claim the Safe Harbour provisions within the Act. So, what are the practical implications associated with the Safe Harbour regime as it was introduced in September of 2017? Again, this is a matter that will be something that is ongoing. It's just simply that the application of the courts to a number of these provisions have not yet been made by liquidators or by directors in seeking those claims. I'm not aware of any existing court proceedings where directors have made claims of Safe Harbour and have been challenged by liquidators. But given that the way in which the legislation is written and the general nature of the sorts of activities that can be undertaken by directors to potentially provide a better outcome for the company, I'm sure that there will be in the next 6 months or so, 6 months to 12 months, a wealth of court cases associated with the matter, and certainly on the proviso that legislation isn't changed in the course of the next 2 years, I'm certain that there will be an ongoing provision associated with the courts and their role in determining what exactly reasonable courses of action are, and also establishing a set of criteria for directors and external advisors as to what could be reasonably considered actions that are going to derive a better outcome, and also when those actions may be reasonably determined to have been ceased as not being successful. So in looking at the matter, in looking at the practical implications of the Safe Harbour regime, the attempts as it's introduced is to effectively encourage informal workouts and encourage directors not to necessarily immediately seek the appointment of insolvency administrators to a company in the event that they fear that the company may be insolvent or likely to become insolvent. to allow them to have a period of time in which they could possibly look at alternatives available to save the business and save the company. Again, as I pointed out previously, those undertakings by directors do not necessarily require that the outcomes achieved in respect of the business, such as the sale or refinancing, result in better returns to creditors in a liquidation scenario. There's no requirement for a director to consider that particular outcome. When the original legislation was introduced, it required directors to consider the outcome on both the company and its creditors, but the requirement to consider the creditors and the outcome on the creditors has been removed from the legislation as passed in 2017. So essentially what it was to encourage informal workout proceedings, to allow, as I say, directors to consider restructuring arrangements, etc., and to remove the red tape associated with formal restructuring through the appointment of external administrators and schemes of arrangement. It's very important to note for your clients, particularly those creditors where you might be advised by a company that it's looking to restructure. There is absolutely no moratorium under the Australian legislation on the ability of creditors to enforce their debt. So if you have a client who is owed money and the creditor or the party to which owes your client says, look, we're looking at trying to restructure and we're looking at Safe Harbour and stuff like that, it certainly does not stop your client from pursuing winding up proceedings. It's up to the company itself and the directors to approach your client and to come up with alternative arrangements. Again, those alternative arrangements are not formal, and so effectively it would be up to a company to establish relationships and establish grounds for seeking a protection from its creditors on an informal basis and on a case-by-case basis, essentially as things go along. That also means, of course, that the consent of secured creditors and major creditors, major suppliers to businesses would need to be obtained by directors who are seeking to go through the process involved in the Safe Harbour, and it would be certainly something that a liquidator would look at in the event of determining whether the Safe Harbour regime is applicable, simply on the basis that, were those consents sought by a director, were they provided, were there reasonable grounds to suggest that the major stakeholders in the particular process or the outcome process would support any restructuring arrangement that the company did seek to undertake. One other question that frequently arises is, how does our Safe Harbour regime compare with those used in other jurisdictions such as the United States and the United Kingdom? And the simple answer is it doesn't really. Those particular processes in other jurisdictions have probably the key component of the jurisdiction of the Safe Harbour provisioning within the United States, the United Kingdom, and say Singapore, is that underneath all those regimes, creditors can be compromised and dealt with formally as part of the restructure. In the majority of those, certainly in the United States and Singapore, creditors are prohibited from taking any further enforcement proceedings under, say, Chapter 11. Once the company has sought to undergo the restructuring process. Separately, however, certainly in both the United States and Singapore, Any restructuring arrangement is effectively controlled to a degree by the court system. Obviously, the bankruptcy courts in the United States, and creditors in general are effectively provided with correspondence and reports, and in certain cases would have a degree of input in the restructuring process. In the Australian model as it's been drafted, there is none of that. Creditors do not need to be formally advised that the company is seeking to go through the restructuring process associated with the Safe Harbour carve-out. And there is, as I've mentioned, no formal process in terms of compromising creditors' debts. Everything's on a case-by-case basis. And there is no restriction upon any creditor from seeking to wind up the company pursuant to their ability underneath the Corporations Act. It's essentially up to directors themselves to make those negotiations directly with the creditors, or external advisors to make those negotiations directly with those parties. In terms of the expertise associated with the Safe Harbour period, should it be applied for by directors. If you'll recall, one of the criteria or potential criteria in determining whether the director had taken reasonable steps to try to secure a better outcome for the company was its engagement of an external advisor. The legislation does not require that advisor is in any way, shape or form an insolvency administrator. It also doesn't require that advisor is an accountant or a solicitor. The advice can be provided by a broad range of individuals. There is certainly some merit in respect of businesses engaging in experts associated within that business model, be they retail experts or waste management experts or mining experts, who may be able to provide a set of circumstances and a criteria for a company to be able to determine or move towards a better outcome for itself during that Safe Harbour provision period. There is no definition associated with the words appropriately qualified entity, and so that's going to become, I guess, something that is going to be determined by the courts. There is certainly an argument within the insolvency and the legal profession, and a degree of caution associated with the Safe Harbour revisions, in that where there isn't a lawyer or an accountant or an insolvency practitioner appointed, a question potentially arises as to the ethics associated with the party that may be providing the restructuring advice associated with the Safe Harbour regime. And again, that comes back potentially to, in certain cases, pre-insolvency advisors negotiating with directors and spending time with directors, seeking to sell the business out and sell the property and plant and equipment out of a business, and then for a director to subsequently apply for the Safe Harbour provisions. And the argument then as to whether that process potentially was something that was undertaken to secure a better outcome for the company, particularly given that the government at a federal level has flagged, as was presented in my presentation of 2 weeks ago, has flagged that phoenixing operations are such a imperative concern for it in the next 2 years, and its indication that it wishes to introduce significant legislation associated with limiting phoenix operations. One thing that will occur is that when insolvency administrators do provide restructuring advice as part of the safe harbour periods. It is likely that those insolvency administrators will be precluded from subsequently accepting an appointment as an administrator or a liquidator. There has been recently, and you may have heard, certainly in the news, the recent decision of 10 Network Holdings and the appointment of Quartermenther in respect of that particular matter as the administrators of that matter, despite the fact that they provided advice to the company prior to their appointment. While it was determined in this particular case that the Quartermenther were not excluded from acting as administrators because they didn't provide advice to the board, its directors, or the management in relation to the management of the group, it should be noted that that particular decision was slightly outside of the scope of the safe harbour regime, and from certainly practical aspects within the ARETA legislation, it would appear that where a director comes to an external insolvency administrator and seeks advice in relation to the safe harbour and whether or not their steps and their actions that they're undertaking would be sufficient to qualify them for protection under the safe harbour regime, that any administrator providing or any insolvency professional providing them with that advice and either confirming or denying that their steps fell within that particular regime would effectively exclude themselves from acting as a external administrator or liquidator at a subsequent date on the basis of perceived conflict of interest. That this will be, I'm sure, a matter that will be at some point in time legislated through the courts or litigated rather through the courts, and it will be interesting to see exactly where the courts have established, but certainly within the ARETA Code of Conduct as it stands, and the General Code of Conduct, which the insolvency law reform has effectively sought to introduce upon the insolvency industry, it would appear certainly that, you know, where we were engaged in, or where any insolvency administrator was engaged to provide advice in relation to safe harbour and to assist the company with its restructuring arrangements during that period, it would certainly not be able to take any subsequent appointment as a liquidator or an administrator and effectively investigate the activities that were undertaken during that period of time to determine whether they provided the carve-out provisions included in the safe harbour regime. So, in summary, or in final sort of presentation, some guidelines that it would be used by this office, and these are just very general guidelines that we would use and do use when we're approached by parties who are seeking to rely upon the safe harbour provisions in a restructuring arrangement. And that's firstly to determine what the better outcome actually is that the company is seeking to achieve, and exactly how the steps that it's proposing to take will lead to that better outcome and establish that better outcome test. We then would establish checklists and risk management protocols to ensure that the activities undertaken by the company effectively lead towards that better outcome, and ensure that there isn't any debt that's incurred that falls outside of the process associated with achieving that better outcome, and thus will be excluded from the safe harbour provisions. To ensure ongoing management of the turnaround process, including lodgement of appropriate documentation, and in particular the tax office ongoing taxation disclosures, and potentially arranging for an independent review of the turnaround process to ensure compliance with the better outcome criteria that were established. In particular, having done a number of restructures myself, there are periods of time in which directors and external providers can perhaps get caught up in the turnaround process associated with the company, and potentially lose sight of what outcomes the company is seeking to achieve, and whether those outcomes in particular are reasonable. And so to have external advice and external review of that process is, I think, critical to ensure that everybody keeps a realistic look at the proposal process. So that concludes my presentation today in relation to safe harbour regimes. Again, should you have any questions at all, please feel free to contact me. And I'm sure the girls here will assist you with providing you with my details. I'm more than happy to have a coffee or have a discussion off the record in relation to the process, should you have any clients who are perhaps even just looking at the matter, or even clients that potentially enter into an insolvency arrangement at some point in time in the future and wish to have a look at whether those safe harbour provisions apply to them, and whether they're able to apply for a degree of carve out as a result of their actions associated in trying to turn around a business. In general, I encourage you to contact the Insolvency and Reconstruction Division at Vincent's. We have a degree of specialisation in turnaround solutions, corporate insolvencies, and personal insolvencies. We've got a substantial number of liquidators available, and bankruptcy trustees available, and we have been engaged on a regular basis in both small, medium and large entities to provide strategic advice on an ongoing basis, and also restructuring advice in relation to seeking to improve a company's financial position, and now compliance with the safe harbour provisions, where a director is concerned as to whether they will be able to fall within those provisions. Outside of that, I thank you for your attendance today, and I hope that this presentation has been interesting to you and provided you with at least an overview of what the safe harbour regime is about. And as I mentioned, I look forward to any questions should you happen to have any. Thank you again. Bye.